People do not have the same rights on their jobs as they have as citizens. Individuals who want to be employed must arrive on time, follow orders, accept limits on their speech and privacy, and conform to a host of regulations. Let's take a look at an introduction to legal rights and responsibilities in public employment. Many workplace obligations and restraints are rooted in the law, and agency leaders must know these principles. In light of these many challenges, perhaps the prudent course of action for a manager to take is to call a human resource professional or attorney with every specific question. Of course, managers should consult with legal experts regularly, but they must make choices daily about how work is to be performed, often with little time or input from others. No matter how complex employment law on a particular topic appears to be, it is typically grounded in the balance of three often competing interests: the need of employers to manage their workforces and operations in efficient ways, the rights that employees have to economic security, privacy, and other matters, and the interest of governments to pursue social objectives through public policy. The balance struck varies from situation to situation and changes dramatically over time. Indeed, as attitudes, social norms, and economic conditions change, previously resolved issues may resurface. There are primary federal laws as well as state statutes and local ordinances that affect the employer-employee relationship. Not surprisingly, these laws frequently conflict, and courts must decide whether one government body's law preempts another. The term preempt generally refers to displacing effect that the federal law has on conflicting or inconsistent state law under the Supremacy Clause of the U.S. Constitution, Article 6, Section 2, but it also refers to the displacing effect state laws have on conflicting local government ordinances. Confusion also occurs when Congress attempts to abrogate sovereign immunity by passing laws supposedly giving state employees the right to sue their state employers. The 11th Amendment of the U.S. Constitution creates a federal system in which each state is a sovereign entity and can be sued only if it consents to be sued. Congress can abrogate this immunity only if it unequivocally expresses its intent to do so and creates a remedy congruent and proportional to the wrong addressed. Judicial opinions are another source of employment law. The United States is a common law system. In contrast, in a civil law system, comprehensive statutes or codes enacted by a legislative body cover almost every subject. A manager seeking to apply the law expressed in a judicial opinion should be aware that only controlling court decisions must be followed. In the federal system, the U.S. Supreme Court sits at the pinnacle. The 12 circuit federal courts, known as appellate courts, make up the middle, and the 90 federal district courts, trial courts, constitute the base. For a court's opinion to be a controlling precedent or binding precedent, it must have been written by a court directly up the pyramid from the lower court. The Supreme Court's interpretation of federal law controls all circuit court decisions, but circuit court opinions binds only the few district courts located directly below it in the pyramid. Federal and state constitutions create legal rights as well. In the U.S. Constitution, the 1st, 4th, 5th, and 14th Amendments conspicuously shape the employment relationship. The Equal Employment Opportunity Commission, known as the EEOC, and the U.S. Department of Labor are responsible for most federal employment laws, and they publish materials about these laws. State agencies enforce and administer state employment laws and publish related materials. While an agency's interpretation of a statute is not binding on a court, courts defer to agencies because of their expertise. Notice the differences among criminal, civil, and administrative laws and procedures. They're important from a human resource management context. Civil law disputes take place in court, usually but not always before juries, and involve private or government parties seeking to determine their rights vis-a-vis each other under civil laws. Administrative law disputes are handled by agencies. Typically, an administrative law judge holds an evidentiary hearing to determine the facts, and an agency head makes a final decision. Procedural rules favor speedy resolution, with short timelines, few motions, and little discovery. The last fundamental principle to bear in mind is the notion of remedy. The remedy is an agency's concrete risk. The remedy is determined by the legal claim being made and the losses suffered. A famous legal maxim holds that where there's no remedy, there's no right. Employers have policies and forms that define the arrangement, but legislatures and courts have added terms to it. At-will employment is the relationship predominantly used by American businesses, and governments use it liberally as well. In its pure form, it means that if the parties do not specify the duration of employment, and most do not, either party may terminate the employment at any time for any reason. Supporters claim that the relationship upholds freedom of contract and fairly balances the interest of employers and employees because either may sever the relationship. But critics point out that many workers need their jobs more than their employers need them, so at-will employment opens the door to abuse. It also subjects families to uncertainty and hardship based on employers' whims. An example of these effects, lawmakers and courts have carved out exceptions to at-will employment that make it unlawful for an employer to take adverse action against an employee for a specific bad reason. The civil rights laws are the most well-known example. As a result of these exceptions, at-will employment now means something different. If the parties do not specify the duration of employment, either party may terminate it at any time for any lawful reason. From a manager's perspective, this means that even at-will employees have many rights that cannot be violated. The reality is, in the public sector, many employees do not serve at will. Legislatures and courts have added conditions to these arrangements as well. The Supreme Court has ruled that when a law, rule, or understanding creates an expectation of continued employment in a government job, then employees possess a constitutionally protected property interest that cannot be taken away without due process. The Supreme Court has also ruled that when a public employer takes adverse action against an employee, it is a state's action, so federal and state constitutional protections apply. As a result, employees who exercise freedom of speech or freedom of association or assert the right to privacy at work cannot be punished if their conduct falls within the ambient of one of these constitutional protections. Odd as it may seem, based on the definition of the word property, in these amendments this includes the right to continued public employment, referred to as a property interest. When an employee has a property interest in a job, he or she also has procedural due process rights. As a result, the employee may not be disciplined seriously unless procedures designed to guarantee fairness are followed. Managers and the courts grapple with two questions that flow from this proposition. What guarantees create a property interest, and, if one exists, what procedures must be followed to give an employee a fair opportunity to affect the result? In Board of Regents v. Roth, the Supreme Court explained what promises raise government employment to the level of a property interest. The employee must have a legitimate claim of entitlement to continued employment based on codified rules or explicitly agreed upon contractual terms. As for the procedures required, prior to 1985, it was understood that a government employee with a property interest who is facing a serious discipline was entitled to the notice of the charges and a post-termination hearing in front of a neutral party. The Due Process Clause also prohibits government from depriving citizens of their liberty without a fair process. If an employee prevails with a property right claim, the discipline is nullified, but she is not reinstated. Her remedy is her liberty to seek other jobs. Formal discipline of an employee is referred to as adverse action. The term encompasses suspensions, salary reductions, demotions, and terminations. Other measures affect employees like reprimands, transfers, alterations of duties, changes in schedule, and denials of promotion, but they usually do not cause serious enough harm to meet the legal definition of adverse action. The right to challenge adverse action has been created chiefly by statute. It's a critical component of civil service systems designed to ensure that discipline and hiring decisions are based on merit, not patronage. Civil servants in classified or covered positions have this right. Probationary employees and individuals in unclassified, uncovered, or exempt positions do not, so they'll be at will. Adverse action rights are created by statute, but procedures also provide due process required by the U.S. Constitution. Either unsatisfactory performance or misconduct may prompt adverse action. The process followed often differs depending on which is involved. The probationary period is the ideal time to weed out employees who are unable to do their jobs. The process used to punish misconduct is often quicker than performance management. Typically, a civil service statute or rule lists offenses that provide cause for discipline. Agencies maximize their discretion by making these lists open-ended, and wherever they're located, agency cause standards should be clear enough to apprise employees of what is prohibitive and to prevent unbridled agency discretion. Public employees may be disciplined for off-duty conduct. Usually, the charge is conduct unbecoming of a public employee or conviction of any crime. Law enforcement officers and teachers especially are held to high standards, but all government leaders worry about their agency's reputations being sullied by off-duty behavior. Generally, a nexus or demonstrable connection must exist between the off-duty misconduct and the job. In civil service systems, the right to challenge adverse action includes a right to an administrative hearing. Governments have created quasi-judicial administrative agencies to hear these disputes. Unions provide attorneys for union members. Non-members in highly compensated positions often hire private attorneys, but non-members in lower salary ranges often represent themselves. On a related matter, a person who is terminated may seek partial, temporary replacement wages while seeking another job by filing for unemployment compensation. Accordingly, an administrative hearing often covers the same issues and involves the same parties as an adverse action hearing. Citizens do not relinquish their free speech rights when they enter government employment, but they do accept restrictions. The First Amendment, which prohibits the making of any law abridging freedom of speech, protects a citizen's right, in limited circumstances, to speak out on matters of public concern. In Pickering v. Board of Education, 1968, the leading case in this area, the Supreme Court balanced employees' speech rights against the need for workplace efficiency. The case concerned a teacher who wrote a letter to a local newspaper criticizing the school board's funding priorities and subsequently was dismissed for disloyalty and insubordination. The court found that the letter addressed a matter of public concern and had not unduly disrupted operation of the school district. Consequently, it held the board could not fire Pickering. To determine whether an employer may take adverse action, a court asks, first, whether the speech was of public concern, and second, whether the disruptive nature of the speech justifies the adverse personnel action. Trying to determine what constituted a matter of public concern proved confusing, so in 1983 the Supreme Court clarified that the speech must relate to a political, social, or other concern of the community. Confusion also arose about whether a comment made as part of a person's job was protected. In a 2006 Supreme Court case, the court ruled that an employee's expression made pursuant to official responsibilities is not protected by the First Amendment. In this case, a district attorney wrote a memo to his supervisors recommending that a case not be prosecuted because he suspected that the sheriff had lied on an affidavit used to secure a search warrant. That individual claimed that he was moved to a less desirable position, transferred to a different courthouse, and denied promotion as a result. The court denied his claim because he made the comment as part of his job. In light of the decision, a supervisor considering disciplining an employee for an expression should ask a preliminary question before applying the Pickering balancing test. Was the speech made pursuant to an employee's official responsibilities? If the answer is yes, the First Amendment is no impediment. Critics predict that this will deter employees from raising legitimate concerns, and whistleblower statutes will not overcome it. Almost all jurisdictions have enacted legislation protecting personnel from retaliatory adverse action when, in good faith, they object to agency misconduct. An employee may initiate a civil action for money and damages in court as a result. Now, government workers are limited in political activity in which they may engage by the Federal Hatch Act of 1939 as amended and state and local Little Hatch Acts. These acts restrict a person's First Amendment right to political expression, but they pass muster with courts because they reduce political coercion of the bureaucracy and promote a nonpartisan, efficient government workforce. Congress retreated from some initial broader restrictions because it feared that denying so many Americans their right to engage in political activity was negatively affecting the quality of the democracy. The impact of this retreat, whether it is repoliticizing the bureaucracy, is unclear. Federal employees are divided into two groups. Further restricted employees in intelligence and enforcement type agencies have little ability to participate in partisan politics. Less restricted employees face fewer restrictions. What happens if a victorious political leader takes office and wants to replace current civil servants with loyal party supporters? Here, the First Amendment potentially paves the way, as it forbids adverse action based on beliefs as well as on speech. In a Supreme Court decision, patronage dismissals are allowed only if the person being discharged occupies a policy-making or confidential position. In a later decision, the court refined its ruling and explained that party affiliation must be necessary for effective performance of the job. A decade later, in another decision, the court extended this holding to personnel actions other than discharge, including hirings, promotions, transfers, and recalls. Now, a government leader who uses party affiliation for any of these decisions must show that it's necessary for job performance. The primary statute covering the right to compensation is the Fair Labor Standards Act of 1938, known as the FLSA. The act prohibits child labor, mandates a minimum wage, and requires that overtime be paid at 1.5 times the regular rate for hours more than 40 hours per week. The FLSA applies to federal, state, and local employees, but lawsuits against states by private citizens are barred by the 11th Amendment's sovereign immunity. Certain FLSA provisions regularly are the focus of lawsuits. The white-collar exemption. This exemption was created to excuse employers from paying overtime to highly compensated employees. Employees engaged in an executive, administrative, or professional capacity are exempt from both minimum wage and overtime requirements. An exempt individual must be paid on a salary basis, earn at least $455 per week, and meet a duties test. Conflicts also erupt over whether idle time is compensable work time. Waiting time, on-call time, sleep time, travel time, and rest and meal periods all raise this question and require managers to examine the precise facts and look for specific rules and guidance from the Department of Labor. The 1963 Equal Pay Act, an amendment to the FLSA, requires employers to pay men and women equal wages for equal work, unless an employer can justify the differential by seniority, merit, piecework, or any other factor other than sex. Public sector pensions are prized by government employees, who see themselves as agreeing to lower wages than they could earn in the private sector in exchange for the promise of a secure retirement, but that promise may be deceptive. The Employee Retirement Income Security Act, known as ERISA, is the main federal law governing private sector pensions, but no public sector counterpart exists. Pensions may be lost due to misconduct. Forfeiture laws in at least 13 states allow public employers to withhold pensions from employees for misbehavior. Finally, scheduling largely is left to employers' discretion, but workers have some rights. The Occupational Safety and Health Act is the main federal statute protecting employees from unsafe working conditions. 23 states have adopted Occupational Safety and Health (OSH) acts for their public and private employees, and a few states have plans that cover only public employees. In general, federal and state OSH acts mandate standards and enforce them through inspections, fines, and closures. The remedies available to injured persons generally are those in workers' compensation acts. In 1908, Congress passed the Federal Employee Compensation Act, and subsequently all states passed worker compensation laws. Through workers' compensation, employees relinquish the right to sue in civil court for on-the-job injuries. Employers forfeit the right to deny benefits to employees whose own negligence caused or contributed to their injuries. These laws are known as no-fault. Employers must finance these systems through insurance premiums or by being self-insured and paying the claims themselves. In the United States, health insurance is provided primarily by employers. Citizens in other industrialized countries have permanent, portable insurance, but American health insurance is usually tied to jobs. Starting in 2015, the Affordable Care Act requires employers with at least 50 employees to offer coverage to people who work on an average of 30 hours per week. Coverage for young adults, same-sex partners, and those changing jobs is also compelled by the law. The ACA requires coverage to be affordable and adequate as defined in the statute. It forbids insurers to deny coverage because of pre-existing conditions, and it prohibits annual or lifetime limits. The Health Insurance Portability and Accountability Act, known as HIPAA, and the Genetic Information Non-Discrimination Act curtailed some exclusions for pre-existing conditions prior to ACA. In addition to insurance, employees need time off for health problems. The Family Medical Leave Act of 1993, known as the FMLA, covers local, state, and federal government agencies and provides eligible workers with up to 12 weeks of unpaid leave during any 12-month period for childbirth, adoption, illness of a family member, or illness of the employee. Conflicts arise when people feel that managers invade their private affairs or private workspaces. There are times when invisible privacy barriers may be breached unconsciously in the regular course of business, such as when a supervisor calls a subordinate at home or searches her desk for an urgently needed work document. The Fourth Amendment, which limits government ability to conduct unreasonable searches and seizures, is the main restriction on workplace searches by government employers. In the leading case of O'Connor v. Otegra, 1987, the Supreme Court held that whether a search violates the Fourth Amendment depends on whether the area is one in which the employee has reasonable expectation of privacy and whether the search is reasonable under the circumstances. The court determined that Otegra, a physician, had a reasonable expectation of privacy in his desk and file cabinet because he was the only one who used the office. He stored only personal materials there, and his hospital employer had never discouraged him from keeping personal items at work. Next, the court asked whether the search was reasonable under circumstances. A reasonable search must balance the governmental interest in efficient and proper operation of the workplace with the employee's privacy interests. It does not require an employer to obtain a warrant or even give an employee prior notice. Managers may wish for a brighter line, but the reasonableness of an employee's privacy expectations and the reasonableness of a search are determined by the discrete facts of each situation. Agencies can take steps to increase the likelihood of searches being lawful. They can reduce expectations of privacy by eliminating personal workspaces and adopting policies authorizing searches. Most employers have policies allowing searches of employees' texts, emails, and internet use on the employer's devices and networks. As a result, employees have no expectation of privacy in these domains, and searches are permissible. Agencies also may conduct video and telephone surveillance if these policies are communicated in advance. In sum, there are few restrictions on the rights of organizations to monitor personnel at work, especially if employees are told about their lack of privacy up front. People consider their clothes and bodies to reflect their individuality and are sensitive to criticism of them. In the legal arena, grooming and dress codes may be unconstitutional or violate anti-discrimination statutes. This is an area where an administrator almost always should ask a human resource professional for help. The First Amendment, free expression and free exercise of religion, and the 14th Amendment, equal protection and due process, afford employees some rights in grooming and attire choices, but courts generally uphold an employer's rule against a constitutional challenge if it's rationally related to a legitimate interest. In Kelly v. Johnson 1976, the Supreme Court's principal decision about grooming, a police officer challenged a county policy limiting the length of male officers' hair. The court concluded that the regulation was rationally related to safety because it provided a disciplined and easily recognizable police force and upheld it. Bans on mustaches, goatees, and beards for police also have been upheld because they promote esprit de corps. Prohibitions on beards for firefighters and mustaches and beards for emergency medical technicians have been upheld for safety reasons. Agencies should be extra cautious about grooming regulations that may limit the free exercise of religion. The U.S. Fourth Circuit Court of Appeals upheld a rule preventing correctional officers from wearing dreadlocks due to safety concerns, even though the hairstyle was required by an employee's religion. But the Third Circuit Court struck down a rule prohibiting police officers from wearing beards because the policy prevented a Muslim man from observing his beliefs. The rule allowed an exemption for a medical need, and the court reasoned that, by allowing the exemption for a secular but not a religious purpose, the county unlawfully discriminated against those with religious motivations. Because of the exemption, the court applied the strict scrutiny standard, which requires a measure to be narrowly tailored and to further a compelling governmental interest. Title VII of the Civil Rights Act of 1964, simply known as Title VII, prohibits employers from discriminating in terms and conditions of employment based on race, color, religion, sex, or national origin. Grooming policies and dress codes are terms and conditions of employment. The grooming policies attacked as gender discrimination primarily have involved different hair length requirements for men and women. Courts routinely upheld such standards if they reflect cultural norms and do not treat one sex more harshly than the other. The grooming rules challenged as race discrimination mainly have been no beard rules. About 25% of black men, compared with less than 1% of white men, suffer from a skin disorder caused by clean shaving, so no beard rules have a disparate negative impact on black men. Dress codes that treat the sexes differently, such as rules that require men to wear ties, are lawful if they do not favor one gender over the other. On the other hand, rules that require only women to wear revealing or physically uncomfortable uniforms, facial makeup, or contact lenses instead of glasses have been invalidated as discriminatory. Policies that limit an individual's ability to observe religious customs have been attacked as religious discrimination. In 1990, a court upheld a state statute that prohibited a Muslim public school teacher from wearing a head covering. Likewise, in 2007, the city of Philadelphia's rule prohibiting a Muslim police officer from wearing a head covering was upheld. In both cases, the courts concluded that requiring employers to accommodate these exceptions would impose undue hardship. Under Title VII, employers must accommodate employees' religious beliefs unless doing so would impose an undue hardship. In 2008, the New York State Department of Corrections settled a high-profile Title VII case by agreeing to determine on a case-by-case basis whether to grant religious exceptions from uniform and grooming regulations. It also agreed to allow personnel to wear close-fitting, solid dark or black religious skull caps, provided no undue hardship was posed. People consider their clothes and bodies to reflect their individuality and are sensitive to criticism of them. In the legal arena, grooming and dress codes may be unconstitutional or violate anti-discrimination statutes. This is an area where an administrator almost always should ask a human resource professional for help. The First Amendment, free expression and free exercise of religion, and the 14th Amendment, equal protection and due process, afford employees some rights in grooming and attire choices, but courts generally uphold an employer's rule against a constitutional challenge if it's rationally related to a legitimate interest. In Kelly v. Johnson 1976, the Supreme Court's principal decision about grooming, a police officer challenged a county policy limiting the length of male officers' hair. The court concluded that the regulation was rationally related to safety because it provided a disciplined and easily recognizable police force and upheld it. Bans on mustaches, goatees, and beards for police also have been upheld because they promote esprit de corps. Prohibitions on beards for firefighters and mustaches and beards for emergency medical technicians have been upheld for safety reasons. Agencies should be extra cautious about grooming regulations that may limit the free exercise of religion. The U.S. Fourth Circuit Court of Appeals upheld a rule preventing correctional officers from wearing dreadlocks due to safety concerns, even though the hairstyle was required by an employee's religion. But the Third Circuit Court struck down a rule prohibiting police officers from wearing beards because the policy prevented a Muslim man from observing his beliefs. The rule allowed an exemption for a medical need, and the court reasoned that, by allowing the exemption for a secular but not a religious purpose, the county unlawfully discriminated against those with religious motivations. Because of the exemption, the court applied the strict scrutiny standard, which requires a measure to be narrowly tailored and to further a compelling governmental interest. Title VII of the Civil Rights Act of 1964, simply known as Title VII, prohibits employers from discriminating in terms and conditions of employment based on race, color, religion, sex, or national origin. Grooming policies and dress codes are terms and conditions of employment. The grooming policies attacked as gender discrimination primarily have involved different hair length requirements for men and women. Courts routinely upheld such standards if they reflect cultural norms and do not treat one sex more harshly than the other. The grooming rules challenged as race discrimination mainly have been no beard rules. About 25% of black men, compared with less than 1% of white men, suffer from a skin disorder caused by clean shaving, so no beard rules have a disparate negative impact on black men. Dress codes that treat the sexes differently, such as rules that require men to wear ties, are lawful if they do not favor one gender over the other. On the other hand, rules that require only women to wear revealing or physically uncomfortable uniforms, facial makeup, or contact lenses instead of glasses have been invalidated as discriminatory. Policies that limit an individual's ability to observe religious customs have been attacked as religious discrimination. In 1990, a court upheld a state statute that prohibited a Muslim public school teacher from wearing a head covering. Likewise, in 2007, the city of Philadelphia's rule prohibiting a Muslim police officer from wearing a head covering was upheld. In both cases, the courts concluded that requiring employers to accommodate these exceptions would impose undue hardship. Under Title VII, employers must accommodate employees' religious beliefs unless doing so would impose an undue hardship. In 2008, the New York State Department of Corrections settled a high-profile Title VII case by agreeing to determine on a case-by-case basis whether to grant religious exceptions from uniform and grooming regulations. It also agreed to allow personnel to wear close-fitting, solid dark or black religious skull caps, provided no undue hardship was posed. The cardinal rule for pre-employment investigations is that they must be job-related. Employers should not inquire about personal matters such as marital status, the willingness of a working spouse to relocate, or if the person has children, because these questions are not germane to the candidate's ability to perform the job. Once a hiring committee crafts its questions, how can it ascertain if the applicant answers them truthfully? Scientific tests are alluring, but the Employee Polygraph Protection Act of 1988 restricts the use of polygraph tests due to concerns about the technology's accuracy. Private businesses rarely are authorized to use such tests. Public agencies are exempt from the act, but the law does not preempt state or local regulation, and about half of the states have enacted an anti-polygraph statute. Even when testing is not prohibited, it has been challenged in court with success. Some organizations seek to refine the hiring process by using personality and psychological tests, such as the Myers-Briggs Type Indicator, which provides information about decision-making styles and interpersonal interactions. If a test is considered a medical exam under the Americans with Disability Act, it may not be administered until after a conditional offer of employment has been made. Medical testing of public sector applicants is usually done to detect drug and alcohol use or the presence of communicable diseases. Post-offer but pre-placement medical exams are permissible and need not be job-related. An emerging concern is the use of genetic testing for illnesses that might affect job performance, such as Alzheimer's disease. The Genetic Information Non-Discrimination Act of 2008 prohibits employers from discriminating on the basis of genetic information. Does an applicant's financial history reveal whether the person will be a dependable, trustworthy employee? Perhaps, but Congress enacted the Fair Credit Reporting Act of 1970 as amended in 2003, in part to prevent employers from using inaccurate or arbitrary financial information. To obtain a credit report on an applicant, the prospective employer must ask the applicant to authorize one. Before taking adverse action based on the credit report, the employer must provide the applicant with a copy and advise him or her of their legal rights. Applicants' criminal history records are important to public employers. The paradox is that about 92 million people, or 1 in 3 adults, have criminal records. Deciding what to do about criminal records reveals a specific policy choice. Governments may disqualify persons convicted of certain crimes, like felonies, for certain jobs, either permanently or for a set period of time, or they may consider each applicant's situation individually, which is best practice and advisable. Should a former employer be able to limit a person's job's prospects by providing a negative reference? There is a striking paradox here between the needs of employers and those of employees. Open communication about employees in the job market promotes efficient hiring, but protecting individuals from defamation is essential. A job reference is defamatory if it contains a false statement that injures an individual's work reputation. Written definition is known as libel, and spoken definition is known as slander. References with unfounded allegations of misconduct, incompetence, poor performance, or other conduct, dishonesty, or falsification of records are defamatory because they may impugn the employee's ability or fitness for a job. Employers who provide job references have a common law privilege that broadly protects them from liability for defamation, but they lose that protection if they provide information that they know is false, act with reckless disregard for the truth, or falsify information, communicate information to persons who are not within the purpose and privilege, or excessively publish it. In addition to this common law shield, approximately 36 states have crafted legislation protecting employers who provide job-related information in good faith. If an agency allows its supervisors to give references, it should provide them with training on how to compose lawful ones. The cumulative effect of these laws is that employers may not discriminate against employees. A host of other federal laws and a myriad of state and local laws forbid discrimination based on additional criteria. In public employment, an often cited goal of anti-discrimination laws and affirmative action initiatives is a representative bureaucracy. Affirmative action programs have increased the overall representation of minorities, but benefited certain groups at the expense of others. More generically, critics contend that current anti-discrimination law is out of date because it addresses only conscious prejudice, not unconscious bias, which persists. The demographic changes in America's workforce pose ongoing challenges to those devising future diversity efforts. The most straightforward claim is one alleging disparate treatment discrimination, also known as intentional discrimination. Under this theory of liability, proving the motivation of the employer is key, but proving a person's state of mind is difficult. A manager's thought process cannot be observed, so her motivation must be inferred from statements and actions. One way a plaintiff may prove discriminatory motivation is with direct evidence, a written or oral statement revealing bias. For example, a supervisor calling an employee a black radical while firing him. The timing and context of a statement are important. For example, a supervisor's remark about Italians uttered to a coworker several months before the employee's discharge was not adequate to prove anti-Italian bias towards the plaintiff at the time of his discharge. The civil rights laws are decades old, and few supervisors, even if they harbor strong prejudices, are unwise enough to vent them. A more common and more complicated way an employee may prove intentional discrimination is through indirect evidence. Here, the plaintiff relies on the employer's actions to support an inference of unlawful motive. First, the plaintiff must present evidence that he or she was treated differently based on a forbidden criterion. Second, the employer can defeat the plaintiff's claim by presenting evidence that it had a legitimate business reason for its action. Third, the plaintiff can introduce evidence to show the employer's stated business reason was a pretext to hide the real discriminatory motive. This analytical approach, known as the McDonnell-Douglas burden-shifting framework, was announced by a Supreme Court decision in McDonnell-Douglas Corporation v. Green in 1973, and it's used in the vast majority of discrimination cases. Employers have many defenses available to them. Typically, an agency argues that the adverse action was prompted by a legitimate business reason and the supervisor had no discriminatory intent. But sometimes the evidence shows that the supervisor had a mixed motive, meaning that he or she was motivated by a legitimate business reason and an unlawful criterion. Under Title VII, if an employer proves it would have made the same decision without considering the illegal factor, the victim's remedies are limited to a declaration that the conduct was unlawful, reinstatement, and attorney's fees. Title VII and the ADAA prevent employers from segregating workers in positions on the basis of prescribed dimensions. But these acts allow segregations in the rare circumstances where there is an essential requirement of the position known as a bona fide occupational qualification, or BFOQ. An example would be auditioning only female actors for a female role. That would be an appropriate and applicable BFOQ. Race or color can never be used as a BFOQ. Today, BFOQs are seldom utilized because they're difficult to defend. Title VII, the ADEA, and the ADA make it unlawful to discriminate against an individual because of opposition to a prohibited employment practice or because of participation in an investigation, proceeding, or hearing. An employee who reports being sexually harassed and is fired as a consequence is a victim of retaliation. To prevail in a retaliation claim, a plaintiff must prove that she engaged in a protected activity, that adverse action was taken against her, and that there was a causal connection between the two. As with discrimination claims, the employer's motive may be proven with direct or indirect evidence. Retaliation claims accounted for approximately 41% of all charges filed with the EEOC recently. Strategically, such claims offer plaintiffs an advantage. Causation is often easier to prove than in discrimination claims. From an employer's perspective, these claims are a distinctive to discipline individuals who recently engaged in protected activity. Title VII makes it unlawful for an employee to be subjected, on the basis of a prescribed criterion, to unwelcome harassment that is severe or pervasive enough to create an objectively hostile or abusive work environment. Many people associate harassment claims with gender discrimination. An example, sexual harassment. But a claim is viable if an employee is harassed due to any characteristic listed in Title VII, the ADEA, or the ADA. Typically, it's the behavior of supervisors, coworkers, and others who interact regularly with the employee that creates a hostile work environment. Whether objectionable conduct is severe or pervasive enough to be unlawful is often the pivotal question. These laws are not general civility codes, and they do not provide redress for behavior that's simply rude, abrasive, unkind, or insensitive. Courts look at the gravity, frequency, duration, character, and threatening nature of the conduct. An employer has a defense to a hostile work environment claim if it exercises reasonable care to prevent and correct the harassment, and if the employee unreasonably fails to use the remedial procedures. An organization can reasonably prevent harassment by adopting adequate policies and procedures, ensuring that all staff members receive the policies, and training supervisors to handle complaints properly. When non-supervisory coworkers or non-employees create a hostile work environment, the agency is responsible if it was negligent, meaning if it knew or should have known about the harassment and failed to take appropriate corrective action. One of the toughest hostile work environment claims to defend against is one that involves tangible employment action. A significant change in employment status, such as hiring, firing, failure to promote, reassignment with significantly different responsibilities, or a significant change in benefits. For manager, the lesson is that all personnel actions should be scanned for proper motivation. Many government employers voluntarily adopted affirmative action plans to increase employees historically excluded in the workplace. They also adopted rules requiring vendors seeking contracts from the government to adopt such plans. These plans used various means to achieve a more representative workforce, including targeted recruitment and training programs, numerical goals and timetables, and special preferences in hiring and promotion. In the 1980s and 1990s, court decisions raised doubts about the lawfulness of these plans under both Title VII and the Equal Protection Clause, and most were modified or suspended. Understandably, critics ask, if race was an unfair criterion to use in the past, how can it be a fair criterion to use now? Title VII protects all groups, including majority groups, from discrimination. As a result, a white employee, for example, who has been treated disparately on the basis of race due to an affirmative action plan may use Title VII to bring action for reverse discrimination. Additionally, Title VII requires any affirmative action program to be described in a formally adopted plan. The plan must remedy conspicuous racial imbalances in traditionally segregated job categories, it must be temporary, its purpose must be to remedy underrepresentation, not to maintain gender or racial balances indefinitely, and it must not unduly trammel the rights of the majority. Under the Equal Protection Clause, a government affirmative action program based on race or ethnicity is reviewed using the exacting strict scrutiny standard. It's constitutional only if it's narrowly tailored to further a compelling government interest. To date, only the goal of remedying past discrimination has been compelling enough for the Supreme Court to approve a plan. Furthermore, the government adopting the plan must provide convincing proof of its own past discrimination. If an affirmative action program is based on gender rather than on race or ethnicity, it receives less rigorous intermediate judicial scrutiny. It will be approved if it has a substantial relationship to an important government interest. In rare cases, affirmative action plans may be involuntarily imposed on employers by the courts to remedy past discrimination. In 1987, for example, after years of litigation, the federal court ordered an Alabama Department of Public Safety to use quotas to increase the numbers of minority state troopers. The Supreme Court approved the plan because of the department's history of overt and defiant racism. These disparate impact discrimination claims most frequently challenge hiring and promotion devices. To aid enforcement, the Equal Opportunity Employment Commission requires employers to maintain records of all hiring, promotion, and firing by race, sex, and national origin. Hiring and promotion test scores must also be kept. To prove disparate impact, an employee must show that a specific selection device had an exclusionary effect. There's no bright line rule stating how much disparity is unlawful, but the EEOC uses an 80% or 4/5 rule of thumb. If the qualification rates of a protected group are less than 80% of the rate of the highest group, then the selection device is suspect. The Supreme Court has disparaged the EEOC's 80% rule and has stated that a case-by-case approach is necessary because statistics come in a variety and their usefulness depends on all surrounding facts and circumstances. Still, since the EEOC investigates and determines the merit of claims, and sometimes prosecutes them, agencies should use the 80% rule as a guide. An employer can defend against disparate impact claims by showing that a challenged practice is job-related and a business necessity. This defense can be used for subjective procedures such as interviews and objective procedures such as tests. To defend tests as job-related, agencies must prove their validity. The EEOC adopted the Uniform Guidelines on Employee Selection Procedures to assist organizations with this endeavor. If a test is proven to have predictive validity, content validity, or construct validity under these guidelines, then it is job-related and it is justified even if it has a disparate impact. Rather than validating tests, some employers have sought to avoid disparate impact claims by using scores creatively. For example, one agency adopted a cutoff score above which test performance was irrelevant. The court, however, ruled that the cutoff score had to be validated. Another agency minimized the relative weight of the exam in a selection process. Here, the court found the practice to be an unlawful affirmative action plan. Others took the top scores in each racial and gender group, a practice known as race norming, which is now prohibited by the Civil Rights Act of 1991. Still others use banding, meaning they treated applicants within certain ranges as having identical scores. So far, this process has not been found to be unlawful, but certain aspects, such as bandwidth, may need to be validated. The ADAA forbids discrimination against those at least 40 years old on the basis of age in the terms and conditions of employment. There is no claim for reverse discrimination by the young. Involuntary retirement generally may not be required, but mandatory retirement is permissible in public safety and executive policy-making positions. Voluntarily early retirement incentives are permitted under the Act. The Act provides a defense for an employer that uses a bona fide seniority system, and in rare instances age may be a bona fide occupational qualification. But employers cannot rely on stereotyped assumptions about older workers' strengths, endurance, or speed. Courts have struck down rules that limited the position of a flight engineer to those under 60 and that of a bus driver to those under 65. The ADA prohibits discrimination against any qualified person with a physical or mental impairment. It also protects those with records of impairment, those regarded as impaired, and those who associate with impaired persons. Employers must provide qualified disabled persons reasonable accommodation. The terms qualified person, substantially limits, and major life activity have spawned considerable legislation. When it was enacted, the ADA was hailed as a major step towards eradicating disability discrimination, but the Supreme Court issued several decisions that sharply limited the scope of the statute. In response, Congress amended the ADA in 2008. The ADA Amendments Act, known as the ADAAA, rejected numerous Supreme Court decisions and EEOC regulations narrowing the Act's coverage, and emphasized the definition of disability should be interpreted broadly. One change is that the determination of whether a person has an impairment that qualifies for coverage now is made without any consideration of the impact of mitigating measures, such as medication or prosthetics. Still, even after these amendments, the line between minor conditions that are not covered by the Act and substantially limiting impairments that are covered are at times fuzzy. To be covered by the ADA, a disabled person must be able to perform essential job functions. This means managers should identify essential job functions in a written job description and ask applicants if they can do them. For qualified persons, accommodations likewise should be determined through individualized assessments. Accommodations that cause undue hardship to employers are not required. These might include, for example, reserved parking, special equipment, personal aids, part-time or flexible work schedules, and building renovations. Title VII does more than simply prohibit religious discrimination. Similar to the ADA, it requires employers to make reasonable accommodations for religious beliefs and practices that do not impose undue hardship. Reasonable accommodation means that which is minimally necessary for the individual to fulfill his or her religious obligations or conscience. Organizations are not required to compensate workers for time off the job fulfilling religious duties or alter work schedules or duty assignments. According to the EEOC, the most common forms of discrimination are 1. Flexible scheduling, 2. Voluntarily substitutes for swaps or shifts or assignments, 3. Lateral transfer or change of job assignment, and 4. Modification of workplace practices, policies, and procedures. The Free Exercise Clause of the First Amendment, as balanced by the Establishment Clause, may expand a public employer's duty to accommodate religiously motivated requests, but the law is unclear. The impact of the Religious Freedom Restoration Act of 1993 on the duty to accommodate is also uncertain. Managers need not accept an employee's suggestion for accommodation, but if the employee offers one, it should be considered. The Religious Discrimination section of the EEOC Compliance Manual is available online and is a helpful resource for managers responding to accommodation requests. Agencies should have and be able to prove legitimate business reasons for the actions they take. First, agency leaders should not act rashly, but should carefully gather and review all the facts before making personnel decisions. They should consciously articulate all job-related criteria. By deliberating with other professionals, managers can make sounder and more defensible decisions. As such, collective decisions are less likely to have been influenced by any one individual's bad motives. Open, two-way communication eliminates surprises, reduces the likelihood of a suit, and increases an agency's odds of winning. This should include regular, timely performance evaluations with positive and negative feedback and articulation of organizational expectations. When problems arise, supervisors should promptly discuss them with staff members and immediately write summaries of these conferences. Documenting such communication not only underscores management's seriousness, but also provides credible evidence. Organizations should have policies in place prohibiting discrimination, should update them regularly, and should ensure that supervisors and employees receive them. Supervisors and managers should treat all complaints of discrimination and retaliation seriously.